Next up on the broadcast, Attorney General Steve Marshall is back in studio with us. Welcome back to the show.
Thank you. Always good to be here.
Thank you for being here. I want to begin with, we're wrapping up Crime Victims Week, and I know that's always a very important week for you, the cause in general, and pointing up the need to always fight for the rights of crime victims.
No, I think that's very much the role that I've had as a prosecutor for 20 years, is that we want to be that voice for those who have been harmed and to make sure that we find justice for them in the criminal justice system. It's why it's a great week for me to be able to travel the state for victims vigils that take place from Florence down to Baldwin County, and then what we've been able to do here on the steps of the Attorney General's office.
You were speaking at an event tonight, right?
Yeah, and really talking about, this year's theme is about honoring our past and celebrating hope for the future. And if you look at some of the champions that have helped victims' rights, the best president during my lifetime, Ronald Reagan, established this week, was very proactive in establishing a task force that developed a multitude of laws to be able to give more rights to victims. We see our very own Darlene Beale, who is a victim herself, that went to Washington, now directing the office that specifically provides victim services across the country with a budget bigger than the general fund of Alabama.
Wow.
And then our own Marion Sheehan, who, as a result of her own tragedy, enduring 7 different trials involving the murder of her own daughter, who came up with the idea that we needed laws in the state of Alabama to help victims, establish Vocal, which has been a vital part of what we've been able to do across the state to be able to help victims and really celebrate that. But then finally, to be able to highlight those organizations that are out there working daily on behalf of victims, our domestic violence shelters, our child advocacy centers, our SANE nurse programs, that really are working to be able to support victims in our communities. And so it's a good week to be able to talk about those things, but also to be very much laser focused on ways that we continue to push that forward, one of which is the legislation that we talked about in the Senate this week involving a revamp of our Board of Pardon and Paroles, because we think it's a system that's broken and desperately needs to be fixed.
I want to go there, but before we do, very quickly, you mentioned the group Vocal, Victims of Crime and Leniency, which was founded by Miriam Sheehan. Vocal presented your office an award this week. The governor helped present it.
Oh, very grateful for the fact that they gave me one of their Voices for Victims awards, along with Governor Ivey. I think she and I both have been very much engaged in this discussion of our parole system. I think Vocal has been one of the leading organizations to bring to the attention of both me, Governor Ivey, and others about what we believe are flaws in the system and areas in which the board itself has operated inconsistent with their own regulations. And so very grateful, again, as somebody that's been prosecuting cases for a long time, to be recognized by that organization for work that we're doing on behalf of victims in this state. That means a lot to me, and I'm very humbled by that.
Now, on to the Board of Pardons and Paroles reform legislation, which was in the Senate Judiciary Committee this week. It did pass that committee, now moves to the Senate floor. You're a big proponent of this legislation because of the problems that you and the governor have been working with the Board of Pardons and Paroles to try to correct, and that was the number of early paroles that were being granted.
No, and not only a big proponent, but we literally are leading the charge as it relates to what's in that particular bill. Very grateful for Senator Cam Ward and Representative Connie Rowe, who both have come together, seeing the same problems that we've seen, hearing the same stories that we've heard, which is an agency that's not accountable to anybody. As a result of issues back in the 1920s, the legislature removed the Board of Pardon and Paroles really from being accountable to either the governor or any other independent body. What we've seen is the fact that we've had those who have committed violent offenses in jail for life sentences coming up for parole after 7, 8, or 9 years. That's wrong. It's an issue of public safety for me. We have a board itself who not only has to make those critical decisions about determining who needs to be released, but somehow or another responsible for running the agency, and I think that's too much on that board to be able to do. And so what we've done, I think, is put forth some very common sense legislation to allow the governor to be able to appoint the leader of the organization of pardon and paroles, to make the board themselves just an adjudicatory body, that they're making those decisions, reviewing files thoroughly before they decide to be able to release somebody, ensuring that we have victim notifications so that those families throughout Alabama that want to drive to Montgomery and appear and protest, that they fully have notice of what's going on. And then beyond that is to make sure that we codify in law, as opposed to regulation, the specific provisions about when somebody will come up for parole, because we saw those rules being abused.
We've talked several times over the last year about this issue, and you said all along that it might come down to making some legislative changes where the Board of Pardons and Paroles is concerned, and we're at that point now.
We are, and again, I very much appreciate Governor Ivey and the leadership that she's shown in this area. She has been very strong through her executive orders. What we're simply trying to do is no longer require a governor to need an executive order to dictate what's going on in an agency, but instead to have her be the appointing authority so that the person running that agency day to day, and remember, we made some significant changes 2 years ago through reforms to pardon and paroles and what's going on at the local level, but yet we've seen that those reforms have not been implemented for whatever reason. At this point, we would give the governor the ability to go to a person that she chose to lead the organization to be held accountable to make sure that those reforms are in place and that we allow public safety to be the paramount concern for that agency.
I believe you said this week, I hope I'm quoting you correctly, that the board needs to realize it's not just a safety valve for those seeking early parole. Am I quoting you correctly?
Absolutely quoting me correctly. In the very first meeting that the governor and I had with the members of the Board of Pardon and Parole, she very pointedly asked them, what do you think your job is? And one of the board members said, it's our job to make sure there's not prison overcrowding. That is not the role of the board. The role should be, and should always be, to ensure the public safety of the communities in the state of Alabama. And one of the things that we do in this bill is to make that very clear, that that is their responsibility. One of their duties is to have public safety always to be that factor for them in making decisions about who should be released.
In the debate over this legislation in the Senate Judiciary Committee this week, I know there was a little pushback about the governor's appointment authority to be able to appoint the chairman. Well, how do you answer those critics who raise those concerns?
Well, I think it's absolutely fundamental that the governor has the opportunity to do that appointment, because right now we have an agency and a director who's accountable to nobody outside of themselves. And so for a governor who's responsible as the chief magistrate of this state, along with me in working on public safety issues, she needs to be able to have direct involvement in not only who's leading that organization, but making sure that that person is responsive to the requests and the needs that she sees. And so we feel very strongly that beginning immediately, not after the current tenure of the current director, but immediately the governor needs to have the ability to decide who leads that agency.
Mr. Attorney General, the Senate Judiciary Committee this week also took up but ultimately carried over a headline-grabbing ethics reform bill that would, among other things, allow gifts to lawmakers from lobbyists. It would lessen the penalties for some ethics-related offenses and would give over a lot of the authority, the investigative authority of these matters, to local district attorneys versus your office and the Ethics Commission. And I know you've said you had some concerns about this legislation.
We clearly have concerns, and we have expressed our objections directly to the sponsor and those that were involved in the crafting of this legislation. Now, I understand where Senator Albritton is coming from, believing that transparency through the reporting is a deterrent.
Reporting of the gifts.
We simply don't think that's enough. And the concern is not only, we put lobbyists in a very difficult position. Let's be candid, is that when they are having outreach from legislators or others asking for certain things, it puts them in a very precarious position as well. And so, one of the things that if you think back to the commission that met this summer, we specifically offered a proposal that said there should be no gifts. There should be nothing that's provided by a lobbyist to a public official, and then we would eliminate that concern. And we still believe that that's an appropriate way to be able to approach it. But yet the framework in which they've chosen to draft this bill greatly limits our ability, I think, to be able to tackle corruption issues. And so we've made our objections known. We believe there's various areas in the bill that that are problematic to us. And candidly, as somebody that's been a district attorney for a long time, that local district attorney doesn't have the resources to fully investigate and vet issues relating to ethics. And so we in the Attorney General's office are uniquely situated. We have talented and experienced investigators who have worked corruption cases their entire careers. We have prosecutors who have tried and convicted those in public office. And we're ready to continue to do that role just like we've done it for years past, and believe that we're the appropriate entity to be able to move forward in many cases. I'm not there to just grab cases away from prosecutors. We need to be there from the beginning as it relates to those referrals, and believe that this current legislation, if it were to pass, would impair our ability to continue doing what we're investigating in certain areas of the state, to be able to hold those who are engaged in unethical behavior accountable under our system of justice.
One other quick question about this bill, and that is the contention by some that local district attorneys, which would get a lot of the investigative authority under this bill, really don't have the resources to investigate some of these cases. Do you agree with that?
Well, I absolutely agree with that. I mean, I've heard that directly from them, and again, as somebody who has sat in that chair, you know, they typically don't have investigators who are actively working cases. They would rely upon local law enforcement to be able to do it. This is a very specialized area. Many times it's document intensive for the records that you're looking for. Requires, I think, a certain level of expertise that you don't just get for somebody that's working other types of cases. It's as specialized, for example, as those investigators that work our child sexual abuse cases, which also require a certain level of experience and expertise. And so I think this is not only a burden on my brethren that are local district attorneys, but also is going to inhibit our ability to effectively investigate and find those who are engaged in corrupt activity.
The sponsor, Senator Gregg Albritton, did agree to carry it over this week, saying he didn't want to rush the issue. Was that encouraging to you, at least?
Well, I think it's encouraging that we're not putting out there what I think is a product that's not appropriate for us in the state. And we'll continue to be able to have discussions with Senator Albritton to the extent he wants our specific feedback. But I would say this, there would be countless amendments that we would offer to this bill to somehow or another get it to the point where we were comfortable with the final product. It doesn't mean that I object to every single word that's in that bill, but yet we do have significant objections about our ability to prosecute, and we think it would be a difficult bill to ultimately amend that we could become satisfied with.
Mr. Attorney General, this week you filed your official response to former House Speaker Mike Hubbard's appeal of his ethics convictions to the state Supreme Court. He has contended, of course, that he felt like his conviction was baseless, that the interpretation used in his prosecution of the state ethics law was overly broad, and that he never set out to knowingly violate the law. You have contended that the conviction should stand, that the law is clear.
Well, and so did the jury in Lee County who convicted him, and so did the Alabama Court of Criminal Appeals, except for one count. And so we believe that not only the words that Speaker Hubbard used back in 2010 that said Alabama's laws were strong and appropriate for this state, they were as true then as they are now. We believe that that particular trial has shown that our ethics laws work and that they can be effective, and we'll continue to be able to make that argument before the Alabama Supreme Court.
Some of the headlines this week about the ethics reform bill we discussed have contended, among other things, that this bill, if it were to pass, would make legal some of the very things that former Speaker Hubbard was convicted of. Do you view it that way?
Well, it takes away some of the particular provisions that were part of the criminal charge in the Hubbard trial. And so again, a very different framework, allowing sort of the disclosure of gifts as opposed to making it criminal, certain things being given as things of value. And so it's a very different approach. Again, it's an approach that we don't believe is the most effective way for us to fight corruption in the state.
But given that your office was heavily involved with those ethics reform hearings that were conducted last summer, there seems to be a lot of genuine concern, is there not, among lawmakers about the ethics law and the need for clarification. And you've worked very closely with that commission to bring about clarification, but not at the expense of the law itself. Right?
Absolutely. And we worked very diligently with that body over the course of many months this spring and summer of last year. And we brought forth proposals that we thought were very appropriate. You know, one of the issues that has been discussed is what is a principle? And so we offered what I thought was a very common sense approach on how we deal with that. A principle being that person who directly controls the activities of a lobbyist. It wouldn't be an entire board of directors, for example, which is one of the concerns that we've heard. We tried to work on issues of thing of value and what is a thing of value to clarify that and to narrow the scope. And also you continue to hear concerns about saying, if I'm in public office, particularly the legislature, it makes it very difficult from an employment standpoint. And we thought that we brought forth, again, some very common sense, clear approach to how to deal with employment questions. Obviously, the sponsors of the current bill didn't choose to adopt our recommendations, but we still believe that provides a framework to the extent that we want to amend our ethics laws that makes sense and don't weaken, but instead clarify where we are.
Mr. Attorney General, you remain very strong in your opposition to illegal gambling. There were some raids in Jefferson County this week. You continue to crack down on illegal gambling operations where you find them. I believe these were bingo parlors, right?
Well, don't want to call them bingo parlors because that would somehow or another make it legitimate. These are casinos that have slot machines that are there under basically an illusory definition of something called electronic bingo. Our Supreme Court has been very clear. Bingo is played on a card against other people in a traditional way that we've always seen it. That's not what's going on there. I mean, these were slot machines row after row in 4 different facilities in Jefferson County, and we're there to be able to enforce the law. And it's not as if I'm on a crusade against illegal gambling. My responsibility as the Attorney General of Alabama is to enforce the law. And that's what we've done in Jefferson County because we saw that it wasn't being done.
Are you watching with interest the lottery legislation that's currently in the legislature? Because among other things, if one of the bills is successful, it would license Greyhound tracks, existing Greyhound tracks, to run video lottery terminals, which some consider slot machines.
One thing that we do is respect the fact that we are a representative democracy. And we have a legislature that has the ability in the light of day to be able to debate the bills and the laws that ultimately become the law of the land. We continue to be able to follow them, to be able to see, number one, we potentially may be the agency that's required to be able to defend those laws if they were challenged, but also we continue to be able to watch and see what impact it has on existing law as well. Some of those bills clearly would, others wouldn't. We'll see where those go and be able to follow them closely.
Finally, before we close, the execution case surrounding Christopher Lee Price this week. He raised some interesting issues. One, he was fighting for an alternate execution method. We traditionally use lethal injection, although last year we passed a new law that would allow for nitrogen hypoxia, and he was pushing for the latter. Mr. Price also contended that there were secret deals going on, that the state maybe was playing favorites with some death row inmates as to what method of execution would ultimately be used with them.
Well, both of those arguments I think fail, and they failed at the district court level when they were considered. Number one, he was given the opportunity to make an election to the new method of execution. He simply chose not to respond, and now comes back now and says, I want to change my mind, I want to make a different choice. He's too late, and so he was given that opportunity. And then beyond that, we've been consistent and thorough in the state as regard the method of execution. Our courts have considered whether or not it's lawful, and they've deemed it lawful, and we believe that both of his claims are without merit.
Attorney General Steve Marshall, always a pleasure to have you on the show.
Thank you. Appreciate seeing you again.
Thank you for being here, and thanks for your leadership.
Thank you.
You bet. And Capitol Journal. We'll be right back.